blastmusic247.com. We're changing the industry, one artist at a time.
Hello, everyone. Happy Thursday. Again, we find ourselves at Friday Eve, and it's time for another great session of the Legal Lounge. I am Nichon Mitchell. I am a licensed attorney. I'm a realtor. I am an insurance agent. My law licenses are in Tennessee and Mississippi. My Texas license is pending. Come on, Texas, y'all! It should be here soon, and then I can help all of my Texas friends. And my realtor license is in Texas, and I have a Texas and Tennessee insurance license, life and health. Why do I have all these competencies? So I can be full service to my clients and help them with everything that they need. So if I sell you a house or you're my buyer, I can put your house in a trust. I can make sure you have enough insurance, life insurance, to protect your family and protect that asset, different things like that. So tonight's topic, we're talking all about deeds. And I wanted to talk about this because when I do estate work for families, when I see trust and I'm engaging in different transactions, there's always a problem with the deeds. And I think that we could catch it on the front end if people understood what they were looking at. So I want to explain deeds, and we're going to get started because, as usual, when I have a topic, it's a lot of information, and make sure you have your pen, have your paper, have your notes. We're going to take a break tonight at 6:30. It's going to be a 2.5-minute break. That will give you time to put your questions in the comment section that I can answer them. It'll give you a chance to, get a drink, go to the bathroom, whatever you need to do, and take a breath because it's a lot. So we're talking about deeds. So before I can even talk to you about a deed, the deed is the piece of paper that evidences your ownership in a piece of real property. That's what the deed is. The deed, it's other things as well, but the way you know it is, it's the piece of paper that shows what the property is and who owns it. So people say, do you have a deed? Do you have a deed? That's what we're talking about. But before I can even talk to you about the piece of paper that is the proof of ownership of the property, I need to talk to you about all of the things that make up the deed so that when we get to the deed, you'll understand why it's structured the way it's structured. So I'm going to start with a few basics, like I always do, and then I'm going to build up to the ultimate issue of the deed. And so we'll be covering that on the second half after the 2.5-minute break. Okay, so the basic part is everybody knows there's land, there's the actual earth, the ground. Okay, so you can actually just own the land. If you own land and there's something on it, an improvement like a house, a barn, a garage, or something like that, that's called real estate then. Okay, now, and I'm saying own, I shouldn't have said it that way. There's land, and then when land has improvement on it, it's called real estate. When you own the land and the improvements, that's real property, realty. That's a real legal definition. So there's a distinction between real estate and real property. Real estate is just a term that means there's some ground, some land that has improvements on it. Real estate. If there's no improvements on it, it's just called land. There's a legal connotation to real property or realty. That denotes that someone owns it and they own all the rights that come with that. So how it's explained in law school and how it works in the legal world is ownership is really it's what they call a bundle of rights. That's the legal terminology, a bundle of rights. What's in that bundle? It's 5 things all together. So how they teach it in law school and how they talk about it out in the legal world is a bundle of sticks. So while I'm talking, each thing I bring up, imagine that you have a stick and we're presenting it that way for a particular reason. So it's a bundle of sticks. One stick is the right to control the property within the framework of the law. The other stick is you have the right to exclude people from the property and not allow them to occupy it. The third one is you have the right to possess the property. The fourth one is you have the right to dispose of the property, meaning you can sell it or otherwise convey a part of it, a piece of it, to somebody or to multiple somebodies. And the last right is the right of enjoyment. You have the right to use the property any way you want to that's legal. So those five things is called a bundle of rights. And the reason why I said think about them as a bundle of sticks, which is how it's taught in law school and how it's looked at in the world in case law and everything, is because those rights don't all have to exist together. You can separate them. For instance, if I own a house and I own the bundle of rights, all five of them, I can take the stick out that's possession and I can rent it out, right? When you rent out a piece of property, you give up your right to possession. The person you rent it to has a right to possession that's greater than yours. So that's why we want to think about these rights individually. They're bundled together and all of them together are your rights, but you can separate them out, okay? So the first big lesson that we are learning on our way to understanding deeds is the piece of property that you're going to have a deed to, you have rights in that property and you have five of them. Okay. Now, so that piece of property that you own, there's a certain way that you own it legally in the law. So regular lay people, all they know is I own a house. That's kind of how they think about it. But there's a particular way to own it. That's called an estate. Okay. There's different kinds of estates, but tonight I'm only going to talk about a freehold estate ownership. I'm not going to talk about leasehold estates. I'm only going to talk about a freehold estate. That is the legal language to say, I own this piece of property. Okay, it's a freehold. Now, when you have a freehold estate, you can own that in several different ways. What you want to do when you buy a piece of property or you buy a house, you want to make sure you're getting it in a estate called fee simple. Okay. Fee simple means I own all of it, all of those rights, all five of them, I own it. If you buy a house like the house you live in and you don't get all of the rights, then you don't own the entirety of the property of the estate. So, and speaking later to this, that is one way that fraud is committed upon a person. Someone will sell you a piece of property, usually not a house, because if there's a mortgage, the bank has checked all this, right? Somebody will sell you a piece of property, but not give you the bundle of rights that I started this conversation talking about. They won't give you all of the rights. They're going to sell you the property at full price, market value, but won't give you all of the rights. That is one type of fraud. That is why we need to know how to read our deeds and read our purchase documents so we can make sure we're getting everything we're supposed to get when we buy the property. Okay, so fee simple, that means I own everything. And y'all in law school, my property professor said, when he was teaching us property, and I'm saying teaching, but law school is a whole different beast in teaching. But he said, if I ever find out one of you in this class bought a house and you didn't buy it in fee simple, I'm going to give you a retroactive F. He was like, that's how important it is to make sure that when you buy property, you buy all of the rights. Okay. There's something called a fee simple defeasible. And I know these are legal words and this might seem like a little much, but follow me because I'm going to break it down. But these are the words you're going to see on the page. And you can always go back and watch this video. You can refer to your notes if you're taking notes. But I need to tell you the legal words because that's what's going to be on the paper. They're not going to talk it down on the paper for you. The legal words are going to be there. And then I'm just going to break it down for you right here. So a fee simple defeasible. So that's when the holder, you're the owner, you have a fee simple. And what happens is your fee simple, your ownership can be cut off when something happens or if something doesn't happen. So there's a fee simple defeasible and a fee simple determinable. But this is all I'm going to tell you about that to make it easy. What those mean is that you might have a deed that says This property can be used only if um, only if it's used for a church or religious functions, right? Um, Deeds can say that. So say you want to leave your property to your church or to someone, but you want them to create a church or something like that, right? Say you put in the deed, I'm deeding you this property, but it has to be used as a church. Okay. So then the person you left it to, they get it, and then they put a liquor store on there. They lose the property. So the big picture on that is it could be any example than what I just gave. But the example is, so like maybe in some families it says, I'm leaving this property to my son, but only if he keeps it in the family and leaves it to his son. If he doesn't do that, it comes back to my estate and then it'll go somewhere else, whatever I provided for in my will. So you can put these conditions, listen to me, in a deed, not a will, right? You can put these conditions in a deed. That's the other reason you want to read a deed very carefully, because it can have conditions in it. Those conditions determine how you own the piece of property. You might own it outright with no restrictions, but you might only own the property if you comply with the restrictions or the covenants or the words in the deed. So you need to know what they say. And I'm just telling you, when that kind of deed exists, that kind of estate has a name, a specific name. Okay. So that is something that you want to know. Let me also tell you about a life estate really quick. You can have a deed. So I can say, this is my house, but I'm giving a life estate to my daughter. She can live here for the rest of her life. And then you can determine after her life what happens with it. You can determine all of that in the deed. Okay, let me tell you why somebody would do that. Sometimes what happens is there's parents that have disabled adult children, and the adult child has a caregiver. They may have an adult child with, severe illness, whether mental or physical, where they have to be taken care of. And the parent wants to make sure that their child is taken care of when the parent passes. So the parent will say, this is my house. I'm leaving this house, a life estate, to my son, for as long as he lives. Now, the other thing you can do is you can leave a life estate that's determined by someone else's life. So you say, I'm leaving this house to my cousin Betty for as long as my son is alive so she can take care of him. So when the son dies, Betty got to go. Okay. So the point that you want to get out of this is there's different ways, different estates that you can create inside of a deed. You don't have to do this in a will or a trust. Inside of the deed to determine what happens with that piece of property. And if you are a property owner, if you are considering buying a piece of property, if you inherit a piece of property especially, you need to see the deed for yourself and read it so you know what's in it. Okay, so we're moving on because time, honey, is moving on. So I want to tell you real quick too about fixtures, liens, encumbrances, and easements, because all of those things will appear in a deed. What is a fixture? A fixture is something that was a piece of personal property, but you permanently attached it to real property and you turned it into real property when you did that. Let me give you a quick example. We bought a water softening system and we put it on the house so we can have soft water, clean water, good water in our house. That's a unit, right? So it's personal property. Personal property is anything you own that's not real property. Everything else is personal property. Okay. But we attached it to the house, and it's attached to the house in such a way that we don't intend on detaching it from the house. That's a fixture that's now permanently with the house. And that fixture is going to be worked into the deed. A lien, most of us know what that is. And the other thing is you got to be real careful. Outside judgments, they'll put a lien on your house. Those can be incorporated into the deed. An encumbrance is a lien is actually a form of encumbrance. There can be other encumbrances. That's something that impairs the ownership. It impairs the ownership. It's attached to the deed, and that affects your ownership. And then an easement is giving somebody a right to be on the property. Some easements, consent to, and some easements you don't consent to, like a utility easement you don't consent to, a railroad easement you don't have to consent to. There are some government easements that they can put on the property. Okay, so and then there's some easements that you give willingly. So I just want you to know about those very quickly because they're going to be in the deed. Once again, if you own property, if you buy property, if you inherit property, you want to know what easements are there. Who has a right to come on the land because that right is running with the deed. Who has a right to be on the land? You want to know that before you buy it. You want to know what liens are already on this property. You want to know that. You want to know what fixtures, just like I said, we attach the water treatment system to the house. We have solar panels. Those are on the house. Those now come with the house. And so you want to know what exactly are you getting and paying for, what's in the deed. Okay. Another thing that I need to explain first before we even talk about the deed and what you're looking for in a valid deed is owning property with someone else, because the deed can name one person. I'm a mother and I have 4 children. If I want to leave this property to the 4 children, I have some different options on how to leave it to them. So there's something called joint tenants. And usually with joint tenants comes the term with right of survivorship. Now, you may have seen that in other places. Like when you go to the bank and you have a bank account, you can leave the account. You can list another joint tenant on the payable on death part. Okay. So you may see joint tenants with right of survivorship in other capacities. So let me tell you real quick how this works. In every scenario, I'm going to use the 4 children that I have. Okay. If I leave them some property as joint tenants, this is how with right of survivorship, this is how that works. When I die, they all have the piece of property equally. If one of them dies, then the 3 own it equally. And when the other one dies, the 2 own it equally. And then the last one that's left owns it all. Okay, that's how that works. Let me tell you how tenants in common work, because tenants in common is another way that you own property with other people, but it's very different. If there are 4 children, and say some of them have kids, some of them don't. When one dies, the other 3 don't get that share. It goes to that person's child or their family member. Okay. And then when the next one dies, the other ones don't get that share. Okay. So as each one of them dies, the others don't accumulate that person's share. It goes to each one of their descendants. Now, why is that important? Because you may not want to be in a home ownership situation with people you don't know. For instance, if you and your 2 college friends want to buy a townhouse together and y'all own it as tenants in common, so you are 3 college friends, y'all are 27 years old, y'all own the condo, one of them goes out and is in a drink and driving accident and dies. The 2 roommates who are left now own that condo with the family member of the roommate who died. You may not want to own property with those people. So the point is, when you are buying or selling or accumulating property, and if you inherit property, you want to know, am I a tenant in common with these people, or are we tenants with joint right of survivorship? Because that's going to determine who you own that property with when as people die and pass. That's what that's going to determine. There's something called tenants by the entireties. That is only available between married couples. Let me tell you how it works. If you live in a state that recognizes tenancy by the entireties, and Tennessee is one of those states, then when you buy a house as a married person, even if you buy it by yourself, your spouse's name is going on that deed. So you might be the only one on the loan, and you might be the only one responsible for it money-wise, but your spouse's name is going on that deed. Okay? That's different than like in the state of Mississippi. If you're married, you can buy a piece of real estate with only your name on it. Now, how that works later, if you get divorced, is there's something called equitable distribution, and the court will be like, okay, well, while you were married, both parties helped take care of the house, blah, blah, this, that. This is how we're going to divide it up. It's going to be taken care of on the back end. But in Tennessee, they take care of it on the front end. And if you buy a house, even if you buy it by yourself, your spouse's name is going on the deed. You need to know that if you're in Tennessee, so you can get a prenuptial agreement that says, whatever property I buy while we're married is mine, and whatever property you buy while we're married is yours. It stays separate property if that's what you want for your marriage. If you don't mind, then just know the default in Tennessee is if you buy a house and you're married, if you buy it by yourself, your spouse's name is still going on that house. You can't dispose of it, sell it, you can't do nothing with it without the spouse's permission. When their name is on the deed. Okay. And then just remember in this section too about how you own property with different people. Don't forget about the life estate, because you can inherit a piece of property, but you may not be able to take immediate possession of it because someone has a life estate. Okay. So, your grandfather may leave you the house, but he's giving his wife a life estate first. And it's like she can live there until she dies. And then when she dies, then you get the house. Okay. Side note about a life estate is whoever is living in the house with the life estate, they own it like they own it. They can rent it. They can get the income from the proceeds. They can do all that kind of stuff. As long as they have a life estate and they live there, it's just like it's their house. So just know that. Okay. Where are we at? 621. Okay. So I'm trying to see where I want to go next to make it make sense. Okay, so what I want to talk about next, real quick, and I can do that before the break in 8 minutes, because when we come back, that's when we're going to get into the different types of deeds and what they're for, what they're used for, and how they actually give you ownership. That's what we're going to talk about when we come back. I want to tell you this part real quick about deeds. I want to give you the history of kind of how it's not the history of deeds. It's kind of the history of how we got to where we're at in American property ownership, to give you some insight also about deeds. There's a question: at what point during the closing are you given the deed? Unless you're paying for the house in cash, well, that's not true. You get the deed. You get it right there at the closing when you sign. So that's a little bit of a loaded question because of how things work technically, but just know when you're at the closing and you're signing all those documents, one of the documents that you're signing is the deed. Okay, let me see. I see another question. Is it difficult to remove a renter who is behind on payments? Maybe not. It depends. Hey, CJ. My son saying hi to me. Okay, all right. So I want to give y'all the history real quick behind some property ownership in America. So April 9th, 1866. Okay. April 9th, 1866. So how many of us remember there was a Civil War, 1865, it ends. The Emancipation Proclamation comes after that. And then what happened was there was a congressman from Illinois who introduced a bill in 1866 that was the first civil rights bill. That bill passed on April 9th, 1866. It passed 1 month after the 13th Amendment passed, which we all know outlawed slavery. So you have the Civil War ending, the Emancipation Proclamation, the 13th Amendment passes, and then 1 month later, the first federal civil rights bill in this country is passed. Okay. So it's the Fair Housing Act of 1866. It established that all people born in the U.S. were U.S. citizens and they had inalienable rights. They all had the same inalienable rights, okay? And that's the right to contract and the right to own property, among other rights, right? So it prohibited discrimination in housing, but how many of us know that was hard to enforce back in 1866, right? So there was technically something on the books about fair housing and the right of everyone in this country to make a contract, i.e. buy a house, and to own property outright, have their name on a deed. So the law was there, but it was very difficult to enforce. It wasn't being enforced. Fast forward 100 years to 1966. Martin Luther King and a lot of other activists, they held a protest in Chicago. It was called Chicago Open House Movement, okay? It included a number of demands that they made on the city of Chicago. Those demands were about everything: housing, transportation, healthcare, income, the wealth gap. They was addressing everything. So how many of us know the civil rights movement in the 60s, okay? 1966, MLK and a lot of activists, the Chicago Open House Movement, that's what it was. So fast forward, the civil rights movement is still going and everything is happening. They're protesting all over. April 4th, 1968, Martin Luther King gets killed in Memphis, okay? So what happened when he was killed was this Chicago movement and a lot of the other protests that were going on around the country, there was a fear that the momentum was going to end because he was killed. So legislatively in the Congress, a lot of things got moving. And Lyndon Johnson signed the Fair Housing Act of 1968. That caused Martin Luther King's death caused that to get pushed through even faster. And it was signed into law the week after Martin Luther King's funeral, the 1968 Fair Housing Law. Okay. Now, when he signed that, what he said was, now fair housing is going to be the American way of life. That's what he said. Okay. The Fair Housing Act prohibits discrimination by direct providers of housing. Direct providers of housing are people selling, is builders, is the mortgage company, is all these people, right? So, and what I want to tell you about that real quick side note is the Fair Housing Act grew over time. It really started out as protection against discrimination in housing for race and national origin. It grew to include sex, disability, family status, okay? So that's that whole idea that usually the civil rights that we have fought for, they end up benefiting more than just us, okay? So we get to 1968, and I'm bringing this all up for a reason, because how many of us know about FHA, right? The Federal Housing Administration. We all know FHA, FHA loans, FHA this, FHA that, FHA, right? So actually, FHA was one of the biggest instigators of segregation in housing in the country. I'm going to read to you a deed from the 1920s, 30s, 40s, 50s, all the way up through the 60s. And I'm going to read this to you, and it's important. It says, this is a deed restriction. This is in a deed in any most typical houses in America. The party of the second part, that's the buyer. The party of the second part hereby agrees that the premises conveyed shall not at any time be conveyed, mortgaged, or leased to any person or persons of Chinese, Japanese, Moorish, Turkish, Negro, Mongolian, or African blood or descent. Said restrictions and covenants shall run with the land, and any breach of any or either of these shall work as a forfeiture of title, which may be enforced by re-entry. So these deeds, all the way up through the late 60s, had restrictions in them that you could not sell the house to people of color or people of certain national origins or backgrounds. I just read the restriction to you. So this said, this deed runs with the land. If you break the deed, you forfeit title, and the person you bought it from can come back in and take the house from you. I'm telling you this because these deeds are still on the record. They still exist. And in some instance, they make it right for fraud. What's another reason I'm telling you this? Because if you're paying attention and watching the news, a lot of the gains from the civil rights era are trying to be overturned. Okay, we're hearing about the Voting Rights Act right now, but quietly, there's a lot going on in housing as well. These deeds are still on the record. They are not currently enforceable because the law came about to make them unenforceable, but the law can be changed again, right? So we need to be very vigilant and mindful about the overturning of civil rights era laws in this country, because we could end up back with deeds that say you can't sell your house to anyone as Chinese, Japanese, Moorish, Turkish, Negro, Mongolian, or of African blood descent. Because these deeds are still part of the record of all the houses that were sold in this country that had that, right? So how many of us know about redlining? This deed is an example of redlining. That's when there was a restriction on where banks would lend, where realtors would allow certain people to buy, and all that kind of stuff. But how was it propagated? Through the deed. It was propagated through the deed. That's how you restricted people from living in a certain area, because you put it in the deed. So you have to, once again, if we're buying property, if we're inheriting property, you have to look at the deed. It's 6:31. So we are going to break. When we come back, we're going to start looking at and talking about actual deeds. Okay. Thank you.
Hands in the air, hands in the air. Hands in the air, we beat the odds. Mental pause in a rhythm without applause. I applaud greater gods, ones that created us in the dark. So now we blacker than, blessed with this blacker skin. And trust me, we living so all this black can win. Pushing again, so you know we tapping in. Don't speak if you don't know what's happening. Demi got up on the mic and rapped again. Messiah, whoever, you know we back again. No more practicing. We been beating the game like Michael Jackson, and got 5 on it like Tito, Jermaine, Marlon, and Jackie. Then I ain't even wanna look back, I'm just rambling. Mind be traveling so many places, can't keep track of mental races. I just scramble through these spaces. Quarterback maneuver, gridiron pen, ink never think give you something smoother. All these lessons I learned, I could be a tutor. I am legend in front of the shooter, and I can hear the world screaming. Hands in the air, hands in the air. And I can hear the world screaming. Hands in the air, hands in the air. And I can hear the world screaming. Hands in the air, hands in the air. And I can hear the world screaming. Hands in the air, hands in the air. And I can hear the world screaming. And I can hear the world screaming.
Hey, we're back. Okay, my loyal watchers, you guys know that this time of night, the sun comes over here and it starts affecting my lighting. So the break actually gave me a chance to kind of work with my lighting a little better. So, okay, we're back. So I just talked to you kind of about the history of fair housing and property ownership. It was a real quick, brief brush, enough for what we need to know to talk about this topic. So we talked about that so that we could talk about deeds. Okay. So I said in the information that I sent out that the quitclaim deed is the most misused deed, and it is. But first I want to tell you about the different types of deeds. So there's several different types, and these deeds are important. They tie into everything that I said earlier. The first type of deed, this is the type of deed that you want when you are buying property. Okay. Get a general warranty deed. A general warranty deed is where the person who you are buying the property from, they give you a warranty against defects. And the most important thing, though, they give you a warranty against is if someone else comes and claims ownership of that land, that house, that piece of property, then the person you bought it from is going to indemnify you and protect you. They're going to step in and say, oh no, I sold it to them and they own it. They're gonna fight that legal fight. They're obligated to, because it's in the deed. It's the type of deed that you got. So you want to always get a warranty deed. There are certain circumstances where a warranty deed is not the general standard practice for that kind of transaction. But for mostly what my viewers, what you all are interested in is, residential homes, even if it's a vacation home, if it's an Airbnb you're getting or something like that, you want a general warranty deed. It's the highest level of deed you can get. It's the highest amount of protection, and that's what you want to get. Okay. So it's gonna protect you. It's gonna protect. Okay, so it's gonna protect you when you get the general warranty deed. The person who gave you the deed, who you bought the house from, is saying, "I'm gonna protect you from anything that happened from when I owned the property and even from before when I owned the property." So they're protecting. So remember, we just talked about the fact that there's still deeds on record that say you can't sell to a Black person or you can't sell to a Chinese person, whatever, right? There's still some deeds in the history of a property that's old enough to have history, right? So say someone comes back from 50 or 60 years, 70 years back, and I say someone, not the actual person, but their family, right? We've seen stories maybe in the news where families are coming back and saying, "Hey, we own that piece of land over there." We know about land disputes. Whoever you bought the land from is obligated to defend you in that action because they gave you a warranty deed. If you get something like a quitclaim deed, which I'm going to discuss in more detail in a minute, there's no protection there. You just standing there with somebody coming claiming that they own your house you live in, or they own this 12 acres you just bought, or whatever. Okay, so a general warranty deed is what you want to get. There's something called a special warranty deed. A special warranty deed is used a lot in commercial transactions, but the bigger difference is a special warranty deed, the person is only going to warrant the property for the time they had it. So they'll say, "Look, I'm going to sell you this piece of property and I will warranty anything for the time that I had it," which might only be 3 or 4 years, 5 years. But they're saying, "But I'm not going to warranty for anything that happened before I had it. I'm not doing that part." And sometimes too, a special warranty deed is used when you're transferring property that you have into a trust. Like if I do a trust for you. Now, I don't use special warranty deeds. I use a general warranty deed when I transfer your property into a trust, but some attorneys use a special warranty deed, and that's not considered wrong to do it if they do it. Okay, what other kind of deeds are there? There's a sheriff's deed. That's what you get when you buy a house on the courthouse steps, and the sheriff is only giving you deed based on his power that came from the court to sell the house on the courthouse steps. So it's not a general warranty deed. It's not the best kind of deed to have. And it is something that can be litigated against. The person can come back and try to get their house, but you're going to get a sheriff's deed. They're not going to give you a general warranty deed. A transfer on death deed, which so a lot of times with these deeds too, you have to make sure that they're available in the state you live in. Some states don't do the transfer on death deed, and that's just it allows the property to automatically transfer to a designated person, and then you don't have to go to probate. So whoever you transfer it to in the deed, "Hey, upon my death, my house goes to my daughter, it goes to my son, it goes wherever," that person just takes over the property and they don't have to go to probate. So you want to make sure, though, that those kind of deeds are recognized in the state that you live in. We talked about a life estate already. That's a type of deed. The other one is in Texas. I think they do a ladybird. Well, probably do a ladybird because she was from Texas. A ladybird deed here is what I said about a transfer on death deed, but the person who transfers it, they have control over what they can do with the property while the grantee is still alive. So they say, "Yeah, I'm transferring this to you. It's a transfer on death deed, but I'm also still maintaining control to do what I want to do over the property while I'm still alive." And so I say quitclaim deed for last because I want to emphasize why I want to talk about this, because I see it used incorrectly, and it's mostly done in situations where there's a large family that has heir property, they have family property, and I see all these quitclaim deeds flying back and forth, and you mess up a lot of ways the ownership of the property. So when somebody gives you a quitclaim deed, it's it's only as valuable as the ownership they have. What a quitclaim deed says is, here, person, I'm giving you whatever ownership I own in this piece of property, I'm giving it to you. Whatever I might own, do own, did own, whatever it is, I'm giving it to you. I'm not providing any warranties. I'm not providing any guarantees. I don't know anything about anything. I know nothing. I'm just giving you what I have. So in families, what usually happens is there was one main person, let's say a grandmother, right? And then she left the house to her 5 children. And then maybe a couple of those children have died and they've had children. And so now you got all these different generations and all these people. And so some people in the family say, oh, I'm going to give you a quick claim. I'm going to give you a quick claim. I'm going to give you a quick claim. So then somebody ends up thinking they own the entire piece when they don't, because whoever gave them the quick claim either didn't have a right to give it to them or they didn't own anything. So what you actually got was nothing. So, all right. So I want to tell you when it's a good time to use a quitclaim deed. This would be a good reason to use a quitclaim deed. I'm going to use myself in several different instances because I always tell y'all I use myself an example. Okay, so I got married a couple of years ago and my name changed. I used to be Nichon Shannon and now I'm Nichon Mitchell. So Nichon Shannon could quitclaim to Nichon Mitchell just to clean up the name change. And I won't have to go through a whole legal process about changing the name. Nichon Shannon will quitclaim to Nichon Mitchell, and now the property is owned by Nichon Mitchell. That's the way to do it. Okay, when I got married, my husband owned a house already. He could quitclaim to me in order to add me into the ownership, officially add me into the ownership, right? He could do that. And he could say, I'm giving you half of my own, whatever I have, I'm giving you half of it. Well, he owns the house. If he wanted to, he could say, I'm giving you half. So that's a way to give a spouse ownership in a property that normally they wouldn't have had ownership in. Those are some examples, some ways to use a quitclaim deed. Now, remember when I said what you get is only as good as what the person owned. So, for example, I could give you a quitclaim deed to my neighbor's house. It could look all official. It's stamped. I can take it to the clerk's office and the clerk will accept it for filing. Then I could give it to you and you have this quitclaim deed over my neighbor's house. But do you own anything? No, because I don't own my neighbor's house. I don't have any interest in it. I could give you a quitclaim deed to the White House. I can do that. But I don't own the White House. And so people are getting quitclaim deeds and then they're coming to me thinking they own something. But when we do the trace back of who had the ownership rights, remember the very beginning of this conversation, I talked about the bundle of rights. Who had the bundle of rights? It wasn't the person who gave you the quitclaim deed. So now you have nothing. When there's been this big family brawl about, oh no, I own this piece, I own this piece, I own this piece. And it's like none of y'all owned anything. So one way to figure out the quitclaim deed, I would suggest if you are in a situation where a lot of people own a piece of land because it's family property, it's heir property or whatever. So there's something called an abstract. And an abstractor will do an abstract. That's when they go to the courthouse and they research the title history of the property. They go back. Usually they only go back 60 years, but you can ask them to go back like 100 years and tell you the ownership track of that piece of property, who owned it, who gave what, and who gave what, and who gave what. How did we get to today? Okay. Side note, that's what the bank does when you buy the house. They get the title history of it, right? You can get the title history of it and then see who has the right to do what, who owns what. Because usually by the time people get to me, there's so much confusion and people have done these quitclaim deeds all over the place. And then they don't want to pay the attorney fee when the attorney fee is $5,000 or $10,000 just for me to sort out who had the right to give who what and who owns the property now. So, but you can get an abstractor. Someone in the family can pay for an abstractor. Have them give you an abstract of title. That's going to run down. If you tell them go back 100 years, it's going to start 100 years. It's going to tell you who owned it and who sold it to who and who sold it to who and who sold it to who. So you can do that. The other thing that's important to have is a survey. You get a surveyor to get you a survey. That's a person who is going to actually go out to the property and define the actual boundaries of the property. So you actually know what's owned and what you're working with. A lot of times families come to me and they say, I think it go down to that creek. The property go all the way to the creek. Don't go to the creek. Mom and them gave that part away. All that part, right? So you need to know exactly what the boundaries are and what you're talking about when you are trying to give deeds to people. People are giving quick claim deeds and they don't even know what the boundaries of the property is. So you have to know that part. You get a surveyor to survey it. The survey is going to cost an abstractor, that's going to cost you maybe, depending on where you live, $300 to $500. A survey, that could be in the high hundreds to a couple of thousand. Depends on how big the property is and the surveyor and all that kind of stuff. But it's very important to have. If you're in a big family or any size family with air property or land that's owned by multiple people, you want to get an abstract of title. You want to get it surveyed. You want to, if there's any wills or documents, you want to get those together. You want to read the deed, the current deed that you're looking at and see. There's a lot of deed fraud, okay? There's a lot of deed fraud. And so that's why when you get to an attorney and it costs $5,000 or $10,000 or $15,000 before you even get to court just to sort it out, because it actually, in literal terms, is a hot mess. And so you have to have like the knowledge and experience of what to do in order to sort that out. But you make the situation worse by all these quick claim deeds flying all over the place. I want to tell you real quick two things. There's something called an action acquired title. That's okay. You use an action acquired title. Remember, I said somebody could try to come to your land and say it's theirs, or you may have an illegitimate child or family member come in and try to get a piece of land, all that kind of stuff. You do an action to quiet title in order to have the court say, okay, I have looked at all the evidence and this is who the property owner is. So if I want to do an action to quiet title in my name, then I file a petition to quiet title in the Nichon Mitchell, a petition to quiet title in the Jones family, or this, whoever you saying is the owner, that's who does the petition to quiet title. So it quiets the title. The court is going to say, you don't have an interest, you don't own it, this is who owns it. And then everybody else has to go away. The other thing I want to tell you is a way to protect your deed. What we've done is we are registered at the county, at the county clerk's office in the county where we live. And whenever anybody files anything on the deed, we get an email. Now we get an email, what we did, it's a broad search and then it's a specific search, right? So sometimes we get an email and it's a false alarm because it's not us. It's just somebody with our same initials or the same first few letters. So we have our name entered down there several different ways. We're going to get notified if something happens. So I did get a notification. Somebody filed something on my deed. What? Who filed something on my deed? I got these papers out, honey. I started looking. Who filing something on my deed? Oh, that was the fixture for that water treatment thing. That's what it was. The fixture filing for the water treatment system on the house, they put that on my deed. Remember? See, it's all coming back around full circle from the beginning of the conversation. Any and everything that's going on with that property is in the deed. Is there an easement? Is there an encumbrance? Is there a lien? What are the right-of-ways? Who's the grantor that's giving it to who? Is it a warranty deed? Everything you need to know about that property is in there. If you are a current homeowner, you should read your deed and understand it. If you are going to buy a home, read the deed and see what it is. Make sure you get a warranty deed. Make sure you get it in fee simple. Now, if you're doing a mortgage, the bank is really checking kind of all of that for you. Make sure names are spelled right. Make sure that your trust or your will works hand in hand with your deeds. When I do people's trust, I get their deeds. I read them. I make sure I do my little check, make sure that nothing, looks funny. And then I, transfer it into the trust. And then I also make sure to tell people, hey, register at the courthouse. Make sure you're getting alerts if somebody files something on your deed. Now, does it stop them from filing a fraudulent or fake deed? No, but you can catch it pretty much instantly. Then you call your lawyer to get on that and fix it. So what else? Let me see if there's questions. Let me see. what I want to tell you about. Let me see. Deed theft scams are on the rise in the states, New York City especially, Texas as well. Yes, yeah, deed scams are on the rise all over the place. But the reason why this was important tonight is because if you don't even know what you looking for, you don't even know it's a scam. If you don't know what's supposed to be there, you don't recognize what's there that shouldn't be there. That's why I wanted to go through this tonight. This, of course, is an introduction. It's a broad brush, but these were the nuts and bolts. These were the important parts that you need to know to at least raise your awareness. You can go research further. You can go do other things to now expand your knowledge in this area. And of course, you can contact me as an attorney, and I can help you, with any issue that you may have in the area of deeds. Jeffrey, who knows me well, Jeffrey, if you need to call me about this issue, you can call me about that, because it said, is it difficult to remove a renter who is behind on payments? Well, what I've noticed in Texas is no, they putting them out, honey. In Texas, you got to go fast. But in some other states, it can be. And then I always want to give the caveat of, like, if I don't know all the facts, it could be something in the fact pattern that is the reason why it's difficult to get the renter out if they're not paying. But generally, it's a process. You got to give them notice. You got to file the detainer action. You got to get them served. And then, eventually you'll get the permission to evict them. And the sheriff, if they don't leave on their own, the sheriff will come and, get their stuff out. So it shouldn't be hard. And a lot of the COVID era protections for renters, those actually kind of just expired. Because they were meant to go on 4 years past the expiration of the declaration of an emergency. And I was seeing on news a couple of weeks ago, I think that time is just now expired. So, all righty, I see Cindy. Hey, Cindy is on here. If you got a question, put it in the chat. I think I may have covered all of the questions. So a lot of the topics I've been presenting they tie hand in hand into the trust and the will that I'm urging everyone to have. And hopefully you see with this deed situation tonight why it's also important to have that. Some of it you can cover in a deed, but it's a lot more protection if you put the house in a trust. It's better protection. It can be against creditors, against someone who may inherit your property who won't take care of it or who won't do what they're supposed to do. You need the life insurance. Remember, I said I'm an attorney, realtor, and life insurance. You need the life insurance if you are someone who wants the house to be paid off so your children, especially if they're minor children, can live there. Like I said before, when I did one on Trust and Wills, how I had my structure when my children were under 18 was I had a will in place, and then I had enough life insurance to pay the house off. So whoever had my kids could live in the house and raise them and get a monthly stipend, or they could sell the house and have the kids wherever they lived and still get the monthly stipend and all that kind of stuff. So you want to have some kind of plan, but a comprehensive estate plan is going to have the trust, a pour over will, is going to have all the property deeded into the trust, and you're going to have some life insurance as the foundation. Even if you don't want it to pay off your house, it's going to be necessary, especially if you have minor children, to help with the transition for whoever's going to care for them, even if that's a surviving spouse, because most households are 2-income households, and you're going to want to replace your income for at least minimum the first year, if not, 2 to 3 years of income to allow that spouse to adjust. Let me see. Yes. Okay. So let me see. Deed theft. Yes. Okay. I don't see any more questions. Let me check my notes, because every time I get off these podcasts, I'm like, why didn't I tell them this? And why didn't I tell them that? I think about all the stuff I should have said, but I think I have covered everything on here. I have one little note, but I don't want to blow y'all mind. That might be a little too much tonight, but okay, I'll say it real quick. In a deed, remember when I said tenants in common, joint tenants, and all that kind of stuff? There's also something where, remember when I said in the deed that maybe grandmama had it, she left it to her kids, and then some of those kids died and had kids? You don't always have to leave it like that. You can make it where grandmother leaves it to her children, and then if some of her children die, it still stays in that generation. The children who die, if they have children, so grandma's grandkids, then they don't get anything. They don't get their parents' share. I'm gonna give you the technical legal term, but only because you might see it in a deed and you need to know that you've at least heard it or seen it before, and you can look it up. When you inherit your parents' share, that's called per stirpes. PER space STIRPES. Of course, it's Latin, per stirpes. When you step into your parents' shoes and inherit their share, that's what it's called. If you don't get to step into your parents' shoes and inherit their share, and your aunts and uncles, everybody keeps it in that generation, that's called per capita. So if you're looking in a deed and grandma gives it to her children per stirpes, that means grandma want her grandkids to get the share that her kids didn't get because the child dies. Okay. If grandma leaves it per capita, that means she only want her kids in that generation to have it. When one of her children dies, the other children get to soak up that one's share. It don't go down to the next generation. So per stirpes per capita. Now, let me tell you real quick why that's important. I got 4 minutes left because sometimes people come to me and say, they come with a deed, it's family property, it's, 40 or 50 people alive, and they say, well, so-and-so in the family wants to sell this property, but I don't want to sell my share. And when I look at the deed, it'll say per capita, and I may be talking to a grandchild, right? Once again, here we go. I'm looking at them saying, but you ain't got a share. It's per capita. You don't step into your parents' shoes, so you didn't get the share. So if you out there and you are part of family property, heir property, whatever, so you need to see what that deed says. Was it per capita or was it per stirpes? That's another way to know whether or not you even had a share to give away in the quitclaim deed that you gave. Okay, so like I said, I'm not trying to bog y'all down with legal terms, but if I don't tell you the legal term, you won't recognize it when you see it and you won't know it's important. Now, I said per stirpes, PER space STIRPES, not per stripes, not per stripes. That's not a legal term. Sometimes I see per stripes and I just shake my head, not per stripes. When you read it, do not read it per stripes. Do not think that it's a typo. The actual word is per stirpes. All of these words that I've given you, fee simple determinable, fee simple condition precedent. These are all legal terms. And like I said, they're not going to dumb the documents down for us. We have to recognize legal words when we see them and seek to understand them. And I hope that this session helped y'all understand deeds better so we can understand the property that we own. Ever since emancipation in 1865, Black households have lost over 11 million acres of land because we have not been transferring it properly. That's one reason. Lately, the past 50 or 60 years, that's the reason. Early on, quite simply, it was stolen from us, right? But remember, you may have a good claim to go back and get that land if you can track the deeds down and understand what they say. So that is something. There's an outfit in Georgia, an organization in Georgia that's doing that. They're trying to help Black families reclaim land that was taken from them. And a lot of that is through the deed search. It's understanding the deeds. So this is a very important topic for that reason. We can recapture some family wealth that way. Can you choose per capita or per stirpes when we own the property? Okay, so it's important to know with a deed that the grantor, the person giving the deed, makes the choices. So if you're the buyer or you're the person who's the grantee, you're getting the deed, you can't be like, nah, grandma, I want it per stirpes or I want it per capita. Grandma get to choose. The grantor, whoever's giving the deed, they get to choose if they're doing per capita or per stirpes. They get to choose. Now, that might be a family discussion or it might be whatever. But the other big thing with these trusts and wills that I want to tell y'all that I do for them, whoever stuff it is, it's their choice. It's their choice of who to give it to. And once again, here's my personal story. My father had 4 kids. He left everything to my brother, the oldest brother. You know, it was his. So what can the other 3 of us say about it? It was his to do what he wanted to do with it. So we don't, as the grantee or the person getting the deed, you don't get to say how you take it. The deed is for whoever owns the property, for them to determine how they want to leave it, pass it on, how they want to sell it, how they want to do whatever they want to do with it. But that's them putting it in there. And then it's for, as the receiver, it's for you to know what you just got. What did I just get from this person? And then you go from there, and then you understand it. But understanding it tamps down the fighting when you understand it. And I just think there's a lot of lack of understanding in the transfer of the deeds. So this recording will be available if you need to watch it again. If you know someone who needs to watch it, please tell them to tune in and look at it. If you know that because these problems are everywhere, just tell them to tune in. And then I have always, as usual, I have enjoyed this. I'm going to go because actually it's third Thursday. Well, it's not third Thursday. Is it? I don't think it is. Anyway, it's my chapter meeting tonight. Delta Sigma Theta. Love y'all. See y'all soon. Bye.